All right, so let's dive right in today
Okay.
with a little thought experiment.
All right.
Picture this. You've got a mathematician, an engineer, and a lawyer, and they're all given a really
Oh, this is going to be good.
simple addition problem.
Okay.
Right, 1.111 plus 8.888.
Right.
The mathematician, without missing a beat, says 9.999.
Of course.
The engineer, ever practical, says, yeah, basically 10, good enough for me.
Makes sense.
But the
There we go.
lawyer looks up and says, what do you want it to be?
Classic.
And you know what? That question might seem like a way to avoid giving a straight answer,
Yeah.
but it actually points us right at what we're exploring today.
Okay. I'm intrigued.
The really interesting world of legal method, and in particular legal reasoning.
So we're going beyond just the rules themselves and looking at how they're actually used in practice.
Yeah, and what that lawyer's response highlights
Mm-hmm.
is that law isn't always just about finding the one right answer in some dusty law book.
Right. It's not as simple as plugging in the facts and getting a clear output.
It's so much more nuanced than that.
It really is. It's about interpretation. It's about argumentation. And yeah, you could even say there's a kind of creative problem-solving element to it.
Absolutely. And the source material we're diving into today, legalmethod.pdf, really digs deep into all of this.
Okay, so what does this legal method lay out for us?
What tackles all sorts of approaches that lawyers use when they're dealing with different sources of law.
I see. So we're talking about statutes, case law, EU law, maybe even things like rulings from the European Court of Human Rights.
Exactly. It's a pretty broad look at the legal landscape. And the key takeaway that runs through it all is that legal method isn't just about mechanically applying rules.
Okay, so it's more than just rote memorization and finding the right paragraph in a textbook.
Right. It's about thinking critically about those rules, figuring out how they interact and how they can be used to build a strong legal argument.
So it's like a blend of abstract reasoning and very practical skills with language.
Exactly. And for anyone listening who's interested in really getting to grips with complex topics,
Which I imagine is most of our audience.
understanding legal reasoning is kind of like a secret weapon.
Okay, I like the sound of that. What
Yeah.
makes it so powerful?
Well, instead of just seeing the end result of a case, who won, who lost,
Right.
you start to see the process that led to that result,
Yeah.
the how and the why.
So it's like peeling back the layers to see the machinery underneath.
Yeah. And that's valuable not just for people studying law, but for anyone who wants to be informed about how the world works.
Especially in a world that's so heavily influenced by legal systems.
Exactly.
Okay, so let's get into the nitty-gritty here. When we talk about legal reasoning, it's obviously more than just finding the right rule in a book, right?
Right. It can't be that simple.
Right.
Because if it were...
We wouldn't have lawyers arguing different sides of a case.
Exactly.
And judges having to make tough decisions.
It's more like a puzzle with lots of different pieces.
And sometimes those pieces don't quite fit together perfectly.
And the people trying to put those pieces together,
The judges.
they bring their own experiences and perspectives to the table.
Right. They're not just robots blindly applying the law.
And that can really influence how they interpret and apply the rules.
So even though they're supposed to be impartial, their own backgrounds and beliefs can play a role.
And a great example of someone who's talked about this openly is Lady Hale.
Oh, the former president of the UK Supreme Court.
Yeah, she's said quite a few times that her own values and background have shaped some of her decisions on the bench.
Really? So she's acknowledging that judges aren't completely neutral observers.
Yeah, and one specific case she pointed to was Radmacher v. Granatino, which was all about prenuptial agreements.
Okay, that was a big one. I remember that case.
And she actually wrote a dissenting opinion in that case, where she argued that prenups shouldn't always be enforced.
Interesting. So she disagreed with the majority of the court.
She did.
Ah,
And she specifically said that her feminist perspective and the fact that the Supreme Court at that time was mostly male influenced her view on that case.
so she felt that prenups could potentially put women at a disadvantage, particularly in situations where there's a power imbalance in the relationship.
Exactly. And what makes the Radmacher case so interesting in terms of legal reasoning is that it illustrates this concept called the inarticulate major premise.
Okay, what's that all about?
It was coined by Oliver Wendell Holmes, Jr.
One of the big names in American law.
Yeah, and it refers to a judge's underlying beliefs or assumptions that might not be explicitly stated in their reasoning, but that can still influence how they decide a case.
So these are the kind of unspoken biases that we all carry with us based on our own life experiences.
Exactly. And in Lady Hale's case, you could argue that her concern for the financial vulnerability of women in divorce proceedings.
Informed by her feminist perspective.
Right, that could be seen as an inarticulate major premise in her dissenting judgment in Radmacher.
So even though she's applying the law and looking at precedent, there are these deeper beliefs and values that are shaping her interpretation.
Exactly. It's like there's this hidden layer beneath the formal legal argument.
It adds a whole new dimension to reading legal decisions.
Right, because you can start to look for those underlying assumptions and biases.
It's like playing detective trying to figure out the judge's worldview.
Yeah, and it can make even the most boring cases a lot more interesting.
So we're not just looking at the what of the decision, but the why.
Exactly. And another legal scholar who really delved into this idea that law involves more than just rigid rules was Ronald Dworkin.
Okay, I've heard of him. What was his take?
He introduced this idea of standards, which includes both rules and what he called principles and policies.
So he's expanding our understanding of what guides legal decisions.
Right, because according to Dworkin, rules operate in a very black and white way.
Like if this, then that.
Exactly.
Yeah.
If the facts of a case fit the rule, then the rule has to be applied.
Okay, so think of something like a speed limit.
Perfect example. If you go over the limit,
You've broken the rule.
plain and simple, but principles,
They're a bit different.
they are. Dworkin argued that principles have weight or importance.
Okay, so it's not just a yes or no situation.
Right. And this means that when principles clash, which happens a lot in complex cases, judges have to weigh them against each other and decide which one should take priority.
So it's more about judgment and interpretation rather than just applying a fixed rule.
Exactly. And our source gives this really powerful example of how this works in practice with the RVR rape marital exemption case.
Oh, that's a landmark case. The one where the court abolished the idea that a husband couldn't be charged with raping his wife.
Yeah, and in that case, the court had to grapple with two competing principles.
Okay, what were they?
On the one hand, you had the principle that you shouldn't criminalize something retroactively.
So basically, you shouldn't punish someone for something that wasn't a crime when they did it.
Right. But on the other hand, you had this fundamental principle that a wife has the right to physical safety and autonomy within a marriage.
And those two principles were directly at odds in that case.
They were, because the husband's actions had taken place at a time when marital rape was still technically legal.
So what did the court decide?
They ended up prioritizing the wife's right to physical integrity.
Even though it meant going against the principle of not criminalizing things retroactively.
Exactly. And that decision really highlights how dynamic and sometimes controversial this process of weighing principles can be.
It's a great example of how judges have to make tough choices based on their interpretation of the law and its underlying values.
And it's also a good reminder that the law is constantly evolving.
Yeah, what might have been considered acceptable legal reasoning in the past might not be acceptable today.
And Dworkin actually took this idea of principles even further in his later work, didn't he?
He did. In his book Justice for Hedgehogs, he argued for a more unified and coherent system of legal values.
So he wanted to minimize these clashes between principles.
Yeah. He believed that principles like equality, liberty, and fraternity, when properly understood, should all work together to support each other.
It's like he was trying to create a kind of grand unified theory of legal principles.
Exactly. He wanted a system where the different parts all fit together harmoniously.
And that brings us to another really important point that our source emphasizes.
Which is?
Even when we're dealing with what seems like clear and straightforward language in legal texts, like statutes or contracts, we can't always assume that there's only one right way to interpret those words.
Okay. So even the plain meaning of the law can be open to debate.
Absolutely. The source uses this great example to illustrate this.
I'm all ears.
Imagine you see a sign that says pork butcher,
Okay.
and then another sign that says family butcher.
Interesting.
Both signs are using an adjective to describe the butcher.
Right.
But in one case, pork tells you what kind of meat they specialize in.
Makes sense.
But family doesn't mean they butcher families.
Definitely not. It probably means something more like they're a local butcher shop that caters to families.
Exactly. The meaning changes depending on the context.
So even seemingly simple words can have different meanings depending on how they're used.
And this is especially true in legal texts.
Because these texts have often been the subject of so much debate and interpretation.
Right. And that leads us to a really crucial distinction that our source makes.
Get me with it.
The difference between whether a conclusion is true and whether the reasoning that was used to reach that conclusion is valid.
Okay. That sounds like an important distinction.
It is, Because you can have a situation where the conclusion happens to be true, but the reasoning that was used to get there was completely flawed.
So it's like getting the right answer, but for the wrong reasons.
Exactly. And the source gives a couple of great examples.
Lamb on me.
Imagine someone's trying to calculate how long it takes sunlight to reach Earth.
Okay.
They could start with completely wrong figures for the sun's distance and the speed of light.
So their starting point is already wrong,
And then they could use the wrong formula.
making it even worse.
But by some fluke, they end up with a number that's actually close to the correct time.
So they got lucky, but their reasoning was completely off.
Exactly. And this highlights a real danger, particularly in law.
Which is
We can sometimes be so focused on getting the outcome we want
the desired result.
that we don't pay enough attention to whether the steps we took to get there were actually logical or based on accurate information.
So we need to be critical of the reasoning process itself.
Not just the final result.
Makes sense. And this ties into the different methods of reasoning that are often used in legal arguments.
Right. We've got induction, deduction, and reasoning by analogy.
Okay, let's break those down one by one, starting with induction.
Okay, so inductive reasoning is basically about moving from specific observations or examples to a broader general principle.
Like the classic scientific method, you observe a bunch of apples falling from trees, and you conclude that there must be some force pulling them down.
Exactly. And in law, this kind of reasoning is often used to develop legal principles based on patterns in previous cases.
But there's a potential pitfall here, right?
Yeah, you might miss a crucial piece of information or a relevant legal precedent.
And that's where the concept of per incurium comes in.
Right, which basically means that a court made a decision without considering all the relevant information.
So it's like they overlooked a key piece of the puzzle.
And then you've got deductive reasoning, which is the opposite of induction.
So instead of going from specific to general, you're going from general to specific.
Right, it's like a mathematical proof.
Okay.
You start with a general principle, like all men are mortal.
Okay.
Then you add a specific premise, like Socrates is a man.
And you deductively conclude that Socrates is mortal.
Exactly. But the weakness of deductive reasoning is that your starting point, your general principle might be wrong.
Or the logical steps you take to reach your conclusion might be flawed.
Right. And our source even mentions the case of Ward v. James as an example of where deductive reasoning went wrong in a legal context.
Interesting. So it's not a foolproof method.
Definitely not. And finally, we have reasoning by analogy.
Which is all about finding similarities between different situations or cases.
Right. And this is really the foundation of the common law system with its emphasis on precedent.
Because courts are constantly looking back at past cases, trying to find similar fact patterns and legal issues.
And guide their decisions in new cases.
But the challenge with analogy is figuring out which similarities are actually relevant.
And how similar the cases really need to be for the analogy to hold up.
So it requires a lot of careful judgment and interpretation.
It does. And it's interesting that judges don't always explicitly use these terms like induction or deduction in their judgments.
Where our source mentions one case where a judge actually did talk about these methods of reasoning.
Yeah, the Home Office v. Dorset Yacht Co. Ltd. case.
What happened there?
Well, Lord Diplock, who was a very influential judge,
Okay.
actually took the time to explain how he was using inductive and deductive reasoning to figure out when the police might be liable for negligence.
So he was laying out his thought process for everyone to see?
He was. And that's pretty rare.
It is. So understanding these different reasoning techniques isn't just for law students or legal scholars.
It's helpful for anyone who wants to understand how the law works.
And it's especially important for lawyers who need to be able to anticipate how a court might analyze a particular case.
Because being able to think like a judge
To see the strengths and weaknesses of different legal arguments.
is crucial for building a persuasive case.
Absolutely. Now, shifting gears a bit,
Okay.
our source also touches on the relationship between law and justice.
Which is something we hear about all the time.
But what does justice really mean?
Right, it's a pretty loaded term.
It is, and our source points out that within the legal system, justice operates on at least two different levels.
Okay, what are those levels?
We can think of them as micro-justice and macro-justice.
So micro meaning small scale.
And macro meaning large scale.
Okay, so what's microjustice?
Micro-justice is about achieving a fair outcome in a specific individual case.
So it's focused on the particular people involved and the circumstances of that case.
Exactly. It's about making sure that the resolution is just for those individuals.
A macro justice.
That's about the fairness and effectiveness of the legal system as a whole.
So it's a much broader perspective.
Right. It's about things like consistency, predictability, the overall impact of the law on society.
And ensuring that the legal system upholds fundamental values.
Exactly. And the interesting thing is that sometimes these two levels of justice can be in tension.
In what way?
Well, if you give judges a lot of discretion to do what they think is fair in individual cases, that might lead to less predictability in the law overall.
Because different judges might make different decisions even in similar cases.
Exactly. And that can make it harder for people to understand their rights and obligations.
So it's a constant balancing act between achieving fairness in individual cases
and maintaining a predictable legal system.
Right. Our source also raises this interesting point about how courts typically need a real live dispute between parties to hear a case.
Why is...
Well, in common law systems, courts generally see their role as resolving actual controversies between people who disagree about something.
So they're not just giving hypothetical advice.
Right. They need a real concrete situation to grapple with.
And our source mentions a case that highlights this principle. R.V. Secretary of State for the Home Department ex parte Shablick.
What happened in that case?
Well, Lord Donaldson, who was the judge in that case, stressed that courts need the specific facts of a real dispute to properly administer justice.
Because otherwise their decision might be too abstract or theoretical.
Exactly.
But there are some exceptions to this rule, aren't there?
There are. Sometimes a court might decide to hear a case even if the parties have settled their dispute.
Okay, when would that happen?
Well, if the case involves a really important point of law that needs clarification, or if it's about the interpretation of a new statute.
So it's a matter of public interest.
Exactly. Our source mentions the Bowman v. Fells case as a good example.
What was that case about?
It involved the Proceeds of Crime Act. And the Court of Appeal felt that it was so important to get the interpretation of that act, right? That they decided to hear the case, even though the original parties had already worked things out between themselves.
So it was a matter of setting a precedent for future cases.
Exactly.
So bringing it all together, it seems like legal method and especially legal reasoning is this constantly evolving process.
It's not static.
Definitely not.
Yeah.
It's not just about blindly following rules.
Right.
It's about interpretation, argumentation, and understanding the broader context.
And recognizing that judges are human beings with their own perspectives and values.
Exactly. And that brings us to our final thought for today.
Okay.
Given everything we've talked about.
About the complexity and the nuance of legal reasoning.
Right. How does this change your view of legal certainty?
Okay.
Do you feel more comfortable knowing that there's room for interpretation and adaptation in the legal system? Or does it make you feel like the law is less stable and predictable?
It's a really interesting question to consider.
It is.
Yeah.
And it really gets at the heart of the ongoing debate about the role of judges in our society.
Are they just supposed to apply the law as it's written?
Or do they have a responsibility to adapt the law to meet the changing needs of society?
It's a tough question with no easy answers.
It is. But it's a question worth thinking about.
Absolutely. And if you're interested in exploring these ideas further, I'd encourage you to look into the concepts of legal precedent, statutory interpretation,
and the growing influence of human rights on legal reasoning.
There's always more to discover.
And that's the beauty of the deep dive.